Hi, Tony DeWitt here, Missouri Appellate Attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about the fact that nobody is untouchable. I'll have more on that in just a moment. I'm going to talk for a moment about Prince Andrew, and I want to make a point before I start. If it is true that Prince Andrew did what it is alleged that he did, which is abuse an underage minor, then there can't be anything bad enough that could happen to him as far as I'm concerned. I don't think that abusing and taking advantage of people of any kind, but particularly in the way that he did, is ever appropriate, and I don't think it's something that you can just walk away from and shouldn't be able to walk away from. But today we're going to talk about some legal issues in the civil case against Prince Andrew. A lot of people have confused the Prince Andrew case with a criminal case, and that's just not where we're at. It is a civil case, and it's about money damages. And the issue in that case was whether or not the release that the young lady signed when she recovered $500,000 in settlement several years ago from the Epstein people, whether that should bar her from pursuing Prince Andrew. So let's talk a little bit about that. First of all, there are two procedural vehicles that you need to understand before you can really understand what's going on with Prince Andrew. And the first of those is a motion to dismiss. Now, a motion to dismiss is designed to get rid of cases that have no legal merit, no matter what the facts are. In other words, there is no legal basis to pursue someone, even if all of the facts are true. And in fact, that's what sets a motion to dismiss apart from the other procedural methods of getting a case terminated. A motion to dismiss means that the judge has to assume that all well-pleaded facts are true. So when this pleads facts about what Prince Andrew did or might have done with this person, those facts have to be assumed to be true. And because they are assumed to be true, that creates an issue for whether or not there is a viable case. If the facts were true, I don't believe there's any doubt that there would be a case there. But the issue in the case, and it was raised in this motion to dismiss, is that this agreement that she signed with the Epstein people somehow clears Prince Andrew. Now, the problem with that is that you're asking the court, where it has to determine or it has to decide that all facts are true, you're going to have to ask it to decide that even if all those facts are true, that this release exculpates Prince Andrew. And in order to do that, you have to get into the document. Except, generally speaking, in a motion to dismiss, the only thing that are considered are the pleadings, meaning in this case, the motion to dismiss and the actual complaint that was filed in federal court. So, although there is a provision that a court can consider an external document if it is integral to the case, for example, in a contract case, it can consider the contract. In a case like this, which is based on tort law, you can't get the contract before the judge to have him interpret it because it's not a part of a motion to dismiss. So even though it was, I think, worth a shot to lay this all out, and this was probably done for public relations benefit more than anything else, it was designed to paint this young woman as a greedy, graspy person who's just out to get money because she was fortunate enough to have something bad happen to her. Again, that's not my characterization, that's the defendant's characterization. The bottom line is, if you assume that all the facts are true, then this case was never going to be dismissed. That doesn't mean that it's not going to go away. What happens after you get past the motion to dismiss stage in a lawsuit is that you begin discovery. And discovery in this case will be brutal. They will more likely than not have to travel to England to go do a deposition of Prince Andrew. And when his lawyers get involved, they are going to have to sit down and do a deposition of this young woman. And the first thing that they're going to ask, I would assume, is who else were you trafficked to avoid getting YouTube upset here? Who else were you involved with in this way that you allege in your complaint? And that could bring up an awful lot of names that are going to make people awfully uncomfortable. So I suspect that her lawyers and his lawyers are going to get an awful lot of pressure to simply pay the woman some money and let her go on her way. But if they don't, and if Prince Andrew really does want to clear his name, then he will push for discovery. Now, I want to show you briefly a picture here of this particular plaintiff and Prince Andrew. If you look really closely at this photograph, this does not look like someone who's being held against her will. And the fact is, I'm pretty sure that she could have walked away at any time that she wanted to. And that is going to figure very heavily in the defense of this case. The defense is going to argue first that she knew what she was doing. They're going to argue that she was in it for the lifestyle. They're going to argue that she was in it for the money and the glamour and the drugs and the cocaine and the champagne and all of the accoutrements that went with being in a lavish Palm Beach mansion. That's what they're going to allege, and that's going to have some jury appeal, I think. And you got $500,000 earlier, and that's going to be in front of the jury whether the plaintiff likes it or not. It's going to be there because she's already been compensated, at least in part, for whatever harm she suffered. And so that's going to be something that the jury has to consider when it's called a set-off. And it may be under New York law, it may be different, and under federal law, it may be different in terms of how that set-off is and whether or not the jury knows that. But if the jury has been reading the newspaper, they're going to know it when they go in there. They're going to know that she settled this case once before. And if indeed her intent in signing that agreement becomes a part of the factual tableau of the case, then again, they're going to know that she settled for a large amount of money and now she wants more, only from a different person. So there are a lot of things in this case that make it very defensible, and it's not something that he should shy away from defending if he really wants to protect his name. However, there are, like I said, going to be a lot of people who very much want this young lady not to tell her story, and you can look for there to be numerous motions to seal her deposition after the deposition is taken. You can just count on that. We're probably never going to get a chance to see that unless somebody from the media successfully moves to unseal the deposition, which is sometimes quite rare. So the case is brought in New York. The jurors in New York are quite sophisticated. And when this supposedly happened, she was 17. I think most people believe that at 17, someone is more than capable of consenting to the type of behavior involved in that case, and in fact routinely engage in that behavior, whether or not they are under some disability with respect to whether they can leave or not. And again, I think that's going to be very, very difficult for someone to prove. Nevertheless, this is an interesting case. As it moves through the courts, we're going to follow it, and I'll bring you up to date on things as things change. So if you haven't already, please go over here and click on the subscribe icon, touch the notification bell so you'll be notified whenever we do a video on this channel. If you would, give me a thumbs up. I appreciate it. That tells the YouTube algorithm that this is worthwhile content. Otherwise, thanks for watching, and I'll catch you on here next time. Have a terrific day.